don't think it's odd. I don't think it's strange for an adoptee to say, I don't have my past. I don't know what I am genetically made of.
She was a black market baby, passed for cash more than 50 years ago with a birth history carefully hidden. But as an adult, a life or death need to know would lead her on a search for her own origins and on a campaign for open access to birth records for all. Adoption and the law on the docket for this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.
It's an area of law that's been amended again and again. Still, the controversy continues as the rights of adoptive children, their birth parents, and their adoptive parents continue to compete. I'm Ray Brown, and on our docket for this edition of Due Process, adoption. State law here in New Jersey was overhauled 2 years ago, but some of the questions are still unsettled. Among them, the rights of adoptees to know their origins. That's the part of the adoption picture that Sandra King fills in for us now. Sandy?
Ray, it was back in 1940 that state lawmakers made it official. Adoption records would be sealed and would stay sealed unless a court decided there was good cause to break the seal. And despite repeated efforts to change the law, including renewed legislation now pending, the no access rule still stands. But that could change this year if adopted men and women like Barbara Cohen get their way.
I knew I was adopted at the age of 10. I was teased by a friend of mine that I was adopted, and I went home. I asked my mother, and she says, yes, you're adopted. And I said, tell me about it. She says, there's nothing to tell, and she walked away.
Still, the older she got, the more Barbara Cohen felt she had to know. But it wasn't until she'd given birth to her second child that the desire to know who her parents had been turned into a life or death necessity.
She was born brain damaged. And all the doctors and nurses and hospitals and specialists that we went to all wanted to know if my medical history, and I could offer nothing.
So the search began in earnest, and at last Barbara and Larry Cohen had some answers.
What we did find was that it was an inherited condition.
The search had taken them to courtrooms, to detectives, to the people who would have the details.
4 years.
How much money?
A lot of money. If you said you were adopted, people looked at you like you had some kind of a disease and they didn't want to talk to you. They didn't want to talk to you because they were afraid that they could be penalized in some way.
Because you had a private adoption, a black market adoption.
It was a black market adoption, yeah. I was passed by doctors and lawyers, and within 2 weeks the adoption was finalized back in 1942, and I was passed for $10,000 in 1942.
By the time she finally got her answers, her brain-damaged child had died, and Barbara Cohen had rolled the dice 2 times, giving birth both times to normal children, against what she would later learn had not been good odds.
My brother and sister had children that they lost from the same condition. My grandmother lost a son, and my great-grandfather lost 5 of his 6 children from the condition back in England.
Cohen says it all would be somewhat easier today.
There's a bill in Trenton, and it's been reintroduced, and it's a bill to give access to adoptees 18 years of age and older, that they would have access to their original birth certificate. And this would allow them, if they need it and if they want it, to have their identity, their birth identity. And I know that within our state and other states, people have petitioned the courts based on good cause, and it depends on how the judge feels about it, whether they give them the information or not.
So Cohen is one of a growing number of adoptees who've joined together to press for a change in the law. What they'd really like is full and open access to records, not only for the adopted child, but for birth parents, too. But 8 years of lobbying has made them more realistic about what they're likely to get. And now they're asking only for access to birth certificates for adult adoptees.
The law of 1940 that sealed the records stated it was to keep the information from the prying eye of the public. But it doesn't say anything about keeping it from the people involved. If you have the birth certificate and you find the birth family and they don't want to meet you, there's a good possibility, a great possibility, that they will pass on medical information through somebody else or send it to you, mail it to you, speak to you on the phone. We're not talking about reunions, our group. We're talking about education and helping people get on with their lives.
And Cohen says that knowing about her past has allowed her to get on with life, not just with a medical history known.
Diabetes, there's heart disease in the family, of course the anencephaly, there's asthma. I have 2 uncles that died from asthma.
But with brothers and sisters and birth mother known too.
I met my mom, my birth mom, and a sister. That's all she did was hold me and cry and said, I never thought this could ever happen. And you really do have to mourn. The adoptee mourns not having a past, and they truly do mourn. The birth parent mourns the loss of the child, and the adoptive parent mourns their infertility.
Still, there's plenty of opposition to open access, especially from some adoptive parents. And the opponents have won some important support for their position from the National Conference of Commissioners on Uniform State Laws. But a law providing for relatively open access, at least to birth certificates, is pending in the state Senate again, and Ray supporters say that this time they think they might have a chance.
Sandy, this still remains a complex and controversial area. And when we come back, we'll hear from a member of the commission that wrote the Uniform State Adoption Law, from a former assemblyman who unsuccessfully tried to open up access nearly 16 years ago, and from a family law specialist who authored the latest update of New Jersey's adoption law. So stay with us.
My brother was adopted, and when he was 19, he did find out.
He did find out.
Yes, and it was good because he got to meet some brothers he never knew he had.
I could see where this would cause an awful lot of trouble, and I would rather see it closed, even though personally I'd like to know.
Me, I wouldn't want to know. I'd probably be curious. I don't know what kind of steps I'd take to actually carry that out, though.
I think a lot has to do under the circumstances in which the person was given up for adoption.
If it was just because my parents couldn't afford me at the time, yeah, I'd want to find out who they were.
But adoptee access to birth certificates is just one of the areas of adoption law controversy. How far do the rights of adoptive parents go? Do they cancel the rights of birth parents completely? And what are we to make of private placement adoptions, open adoptions, black market adoptions? Here to help us sort it all out, former Assemblyman Albert Burstein, who once led the campaign to open adoption records. Barry Evanchik, a New Jersey member of the Uniform State Law Commission. And from our studio in Newark, family law practitioner Toby Solomon, who wrote the latest amendments to the state's adoption law. Barry, Mrs. Cohen's story is a pretty compelling one. What has led your fellow commissioners to take a position in opposition to access?
Well, I think the sense of the commission was, as a result of years of study and debate, that it was best for the person who gives up a child, or the parents who give up a child, not to be troubled again by having that fact, that event, come back and become public. I must tell you that while serving as a member of the commission that studied adoption law, the subject of access to these records wasn't really uppermost on my mind. What was uppermost was seeing a uniformity brought to the law, which was sadly lacking, still is in many states.
I understand, though, that you've actually changed your position in the last year or so on this position of access. What caused you to change your mind?
It's not so much that I changed my mind as I was most impressed and am now fully sympathetic to the viewpoint of those adoptees who say, I need to be able to get to know where I came from, who my birth parents were, who my birth mother is. Barbara Cohn is one of a number of people who have come to my office in the past year and spoken of this particular topic. Their eloquence, the passion.
So Barbara Cohn, the lady in our package, was one of the people who began to lead you to rethink your position.
Indeed. I was persuaded as a result of hearing her story and many others that there's really no reason to keep these records sealed up as if they were nuclear secrets.
Now, Assemblyman Burstein, you've been involved in this process for a long time. Who is it that's on the other side of this position? I know you favor open access, but who are the people that you've listened to and known about who are opposed to open access, and what are their concerns?
Well, obviously the concerns are that what was a confidential relationship at the time of the termination of parental rights can be revisited. People are uncomfortable about that. The natural parent conceivably would be uncomfortable about that.
What about the fears of adoptive parents that this may lead to the natural parent coming back and reclaiming the child, or in some way undermining the family solidity that they've tried to build?
I think that's an exaggerated fear. I don't believe anecdotally, from what I understand to be the fact in those circumstances where an adult adoptee has actually found a natural birth parent, that happens. When you're raised by your adoptive parents over a lengthy period of years, you come to establish that bond and the affection that is natural for all naturally born persons. So I don't think that really happens. It's an exaggeration.
Well, as we stand now, the legislation that's pending would only give access, what, to birth certificates?
That is my understanding.
And to whom would it give that access, Barry?
Well, it would give it to the adoptees.
So why is there a controversy? I mean, that seems like a very little bit of information to give. Why is there still controversy about it?
Because it opens the door, and the theory is once that door opens, there's no longer any confidentiality at all. Now, I've heard it said that one fear of those who are pressing for confidentiality is that a person would be disinclined to carry a child to term. That indeed, if these records became open and available, some birth mothers might be inclined to seek an abortion rather than go through with the delivery. I've heard it said, but I must tell you, I've seen no data, no respectable evidence to support that claim. Yet it is one of the things that we heard in the national conference as being a reason.
Let me draw on your skills of political prophecy. Is this going to pass?
I think that the atmosphere is such that there is a good likelihood of a sympathetic hearing in Trenton for the bills now pending. And one of the things that has...
Sympathetic hearing means that it'll pass or won't?
Well, that's hard to say. I don't make predictions about legislation these days.
But it's because of your ability to do that we asked you to come.
Oh, is that? Well, then I'm forced to.
Okay. Do you think it's that close a question that you wouldn't at this point say affirmatively it's going to pass?
I think that there is a receptivity to the bill now that didn't exist before, and I think it will pass. It's been narrowed down to access to birth records only. My personal inclination is that the accessibility should be not only to birth records in aid of an adoptee's search, but also to agency records where there has been an agency involved in the adoption process, and to court records. Obviously, the court necessarily has to be involved in the adoption process. All of those areas are areas where an adult adoptee should have access, and there's really no reason why it shouldn't happen.
Right. Toby Solomon, this is not the only area of controversy surrounding adoption law. You've been working on some amendments, and the fact is that much of the concern in this area concerns the issue of private placement and how that can be done responsibly.
Well, Ray, firstly, there was an expectation of privacy when these adoptions were put through years ago. And there are excellent arguments and very compelling arguments on both sides of the issues. The compelling argument for an adoptee is might want to find the medical history, the background, the genetic background, besides the emotional the compelling emotional issue of finding your roots, so to speak. However, everyone seems to think that it's the adoptees and the birth parents will be happy when they are found by their, the children they placed long ago for adoption. But there are certain birth parents who haven't told their new families, who have other children, who have husbands who don't know about this, and they really don't want to have this past door open in their lives.
So you're saying that the issue of who favors what side is somewhat more complex than we've already
It's very complex, and there are states who have solved this problem to the somewhat by having what we call a mutual consent registry. And under a mutual consent registry, the adoptee over 18 years old would register, and so would the birth parents. Now, obviously, you know, some people might not know to do this, but that is one solution to this problem, where if there is mutual consent and people want to find each other, they will be helped to find each other.
Now, I know that we've talked a lot about access, but there are other areas of controversy in the realm of adoption law, particularly the question of how to regulate or deal with private placements. Have you been concerned about that?
Well, as you know, I with my committee drafted the new amendments, and the new amendments actually have a lot more safeguards than the prior statute. So we were in favor of private placements. We feel that it helps children be placed in homes. Prior to the new statute, you cannot introduce a birth parent to a prospective adoptive parent. Now, lay people didn't know about this, so obviously they thought they were doing a good deed.
But it was actually a violation of the law to do it?
Absolutely. So if you had a friend who wanted to adopt and maybe another friend who wanted to place a child, you really couldn't make this introduction.
What does the change now permit? Can anyone introduce two together?
Yes, as long as you're unpaid, no baby selling involved, you could be an unpaid intermediary under the law and an introducer. Let's call the intermediary introducer, so that you could make this match. And under the new statute, we have a lot more safeguards than the previous statute. For example, you can't put prospective adopted child, you can't put this in the adoptive parents' homes without what we call a home study, and that would be only done by a licensed New Jersey agency.
Let me interrupt you and ask you one question that I may then also point to an old legislator if we can find one, and that is, do you think this concept of the unpaid intermediary may open the door possibly to abuses in the form of a black market that's disguised?
No, I don't, because there are a lot more safeguards. You have to put down, the court reviews this. The intermediary has to be set forth in the court papers. There have to be a criminal record check now of the prospective adoptive parents. There have to be fingerprint checks. And I think if you see the same people acting as unpaid intermediaries, then you will have cause to be concerned.
Assume that two people meet to discuss such a process of adoption. At what point does the court become involved?
The court becomes involved actually when you file your complaint for adoption and your other necessary documents. However, if it's an interstate adoption, the interstate compact administrator must be aware of this adoption. There must be many documents filed. For lay people who are watching this program, we have a statute, and let's say we're doing an adoption with Arizona or Virginia, and the adoptive parents are in New Jersey. Arizona would be the sending state, and New Jersey would be the receiving state, and there are a lot of documents, including the home study and medical background comprehensive form that must be signed. Also, you have to set forth how much money you have paid to help the birth mother with her reasonable living expenses. So it goes through many sources. The agencies will see this, the interstate compact administrators in both states, and then the court will
I think Barry wanted to add something.
Well, I wanted to say I think Toby is quite right in describing what is the law in New Jersey, and I think she and those who were part of the process of drafting our current statute ought to be commended. But she also commented a moment ago on the interstate aspects of this, which brings me back to my role as a uniform law commissioner, and I don't want to fail to mention that uniformity in this area of the law is awfully important. Now, New Jersey happens to be an enlightened and I think forward-thinking state on this subject. There are many states far behind us in terms of the adoption laws, but we ought to try to prevent the unseemly situation of an adoption beginning in Arizona and ending up in New Jersey and having different results depending on fortuitous circumstances.
Let me go back to one of the areas of public concern which touches on your concern and opinions that Toby's expressed, and that is that let's assume that the dealing is with people in a state where there is no regulation or perhaps even a foreign country. Why, former Assemblyman Burstein, might there not be an invitation to abuse in terms of paying people, which we know has gone on in the past, and setting up a black market which undermines the ability to regulate and make sure this is done in a proper way?
Well, the black market in babies is cited in a foreign jurisdiction, whether it be another state of the United States or outside the country. That's something over which we have little control, except that investigations are made before there is any complaint filed. There has to be an agency investigation of the source of the referral, of the baby referral. And I think that one of the things that Ms. Solomon's committee is to be commended upon is the fact that they have now adopted a statute which faced the reality that existed before, but without the safeguards that are incorporated in the statute. We have had personal placements going back a long period of time during a section of time when private placements were not recognized by statute in New Jersey, and things were done sub rosa. Now I think that the kind of investigation that is mandated, where you have personal adoptions, private placement adoptions, is all to the good. And I can't foresee any kind of real problem arising in the sale or the resurrection of the black market baby scandals of many years ago.
Toby, one of the other issues that seems to be of public concern is that once a child's been adopted, the likelihood of a birth mother showing up and making a claim. How often does that happen, and what kind of safeguards are in place concerning how and when an adoption can or should be terminated?
An adoption cannot be finalized over the objection of a birth parent unless that birth parent has her rights terminated by a court. Generally, what we're speaking about is a voluntary placement by a birth parent. And once she surrenders those rights, either judicially or through an agency, it is irrevocable. The fact that she might show up is something that perhaps can't be helped, but she will have no rights to that child.
What happens in a case in which there may be a father who's not aware of the adoption at the time it takes place and shows up later? Does he have any rights, and does that complicate the legal process of making this a final termination, final by the court?
Absolutely. We're getting back to the baby Richard and the baby Jessica cases, and that is always a problem. I might say that New Jersey and the Uniform Adoption Act, to which Barry referred, are very similar. New Jersey is in the forefront, and I have spoken to the reporter, Joan Hollinger, at length.
What's the solution that New Jersey and Barry's commissioners have brought about to that problem? What's the solution to the father who learns 2 years afterwards of the adoption and wishes to intervene and terminate it?
In New Jersey, we haven't addressed that in the statute. In the Uniform Adoption Law, it's addressed that after 6 months, that father will have no rights. Now, I don't know if New Jerseyans and the legislature would accept that approach, because the birth father who has been misled or given misinformation or deceived would have no rights. So that is a very, very difficult question, because it's his interest against the best interest of the child, having been in that home and bonding with the adoptive parents.
If you were governor tomorrow, what would you recommend to the legislature be New Jersey's approach to that problem? Because certainly this has created a lot of public interest and even unrest about how this matter can be resolved. What would you do? We've made you governor.
I think I would appoint a committee to study it.
Oh, that's terrible. Well, since Barry would be chair of your committee, no doubt, Barry, you give us the proposed solution.
I think we have a solution, and by the way, both the National Act, which is still a proposed act, and the New Jersey statute do have some protections against the kind of horribles that we've been talking about. For example, the law in New Jersey is that there must be genuine efforts made before an adoption can be finalized to find the father if indeed the father has made no appearance at all. Genuine efforts to give notice, and those are not just casual. If you look at the statute, there's a long list of steps that must be taken under the supervision of a court. So the kind of situation that occurred with the baby Richard and the baby
But 6 months, Barry, seems like a short time. There can be an estrangement of 6 months or 8 months,
right,
which could then lead to a real tragedy. Go ahead, Toby.
I'm involved in such a case now. The abuses will always exist. If a birth mother wants to place her child and not tell, and say that the birth father is unknown, there is no way we are going to find out who that birth father is unless he finds out by some other mechanism.
But if I were a parent looking to adopt, I would be very concerned about the lack of finality involved if I knew that some father, even perhaps a man who might be sympathetic, could come and essentially disrupt and perhaps terminate and create psychological harm for the child by ending a relationship.
You're absolutely right, and that's why when we have a client that has a situation, that client has to sign a legal risk acknowledgement, which is one of the things the Interstate Compact also requires in New Jersey. And that is a high-risk adoption, and you have to make this known to your client.
Now, one of the things that impressed me very much in the package we did was Barbara Cohen's talking about health care questions and her inability to know about things that could be vital to her survival or survival of her children. Does that remain an area of controversy, given the fact that the State Assembly and legislature haven't acted and we're still looking at possible non-solutions here in New Jersey?
Well, even I might say under the new act, we get a total medical and genetic and social history to the best of our ability. This is required by the Interstate Compact, this is required under our statute, and this is just common sense.
We're winding down. Assemblyman Burstein, you
Even before the adoption of the new statute in 1994, you could apply to court where you needed non-identifying medical characteristics and obtain relief from the courts.
It sounds to me like there's still a lot of areas to resolve, complicated by the fact that jurisdictions look at this differently. Barry?
I think so, but the one that I believe emerges as the most important is this question of secrecy. And it's time we eliminate secrecy, and it's time the Barbara Cohens of the world be permitted freely to know their roots, their origins, who they are.
Well, we certainly know a lot more about adoption than before we started, and I want to thank you all for being with us. And that's it for this edition of Due Process. But I hope you'll join us next week when we turn from adoption, one of the most controversial areas of civil law, to what may still be the most controversial issue in criminal law. It's the death penalty on the docket for the next Due Process. Till then, I'm Ray Brown.
Everyone questions at some point in their life who they are. When you're in high school, you wonder who you are, what you're going to be like, who you're going to be like. When you're in college, you question, am I doing what's right? What should I be studying? Who really am I? What am I interested in? What do I want to do with the rest of my life? I guess in middle age, too, there comes a time where you really question, am I doing what I really want to with my life? Because it's more than half over. So I don't think it's odd. I don't think it's strange for an adoptee to say, I don't have my past. I don't know what I am genetically made of. I know what my environment is, but genetically I don't know who I am. And I want to know. I want to know before my life is over. It's important to know.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual, publishers of print and electronic information for and about the legal community, including the legislative manual.